In here, in the room 1000, we're continuing on. First speaker in the afternoon is David O'Leary. David is a chartered surveyor with over 25 years experience in private practice, including 15 years as a practicing mediator, conciliator and arbitrator. He's also a barrister at law, non-practicing. David has worked on a wide range of commercial, industrial, health, education and heritage developments. He's been appointed or nominated at various times as arbitrator on construction disputes by the President of the Royal Institution, the Architects of Ireland, President of the Society of Chartered Surveyors and the President of the Construction Industry Federation. David is also an author and presenter of conciliation courses and workshops to the Royal Institution, the Architects of Ireland and the Society of Chartered Surveyors and the Construction Industry Federation. His extensive lecturing experience and the public works contracts to government departments, public bodies and professional institutions. Today, David will give us a presentation on the nature and current position of construction disputes resolution in Ireland. Thank you.
Thank you, Martin. Good afternoon, ladies and gentlemen. The presentation I'm going to give was prepared, in fact, by Jerry O'Sullivan, who unfortunately couldn't present it here today, so he's asked me to present it for him. So if I look a bit confused by some of the stuff coming up, it's probably because I am. This is Jerry's presentation, but we'll go through it and we'll take questions later on it. So the content of this presentation is to deal with the Society of Chartered Surveyors of Ireland's Dispute Resolution Standing Committee and the activities ongoing there at present. So we look at published panels and appointments, adjudication training, which is going to come in fairly shortly and fairly rapidly, expert determination, conflicts of interest, which are always a topical issue, and some other planned issues that the Society will be dealing with. I'll then have a look at the Adjudication and Contracts Bill, which is going through the system at the moment. And we look at adjudication procedures, panels, codes of practice for adjudication, and some recent UK case law in adjudication. They've had adjudication in the UK now for 14, 15 years. I'll then look at some current issues on the Arbitration Act 2010, and then I will have a look at what's going on presently in the Liaison Committee, which is a committee jointly between the Royal Institute of the Architects of Ireland, Engineers Ireland, Society of Chartered Surveyors Ireland and the Construction Industry Federation. And in there at the moment we're looking at a Dispute Resolution Clause review and a revised RIAI contract. And then finally and briefly I'll have a look at some current issues on conciliation. The Society of Chartered Surveyors Dispute Resolution Standing Committee had an agenda there for 2011-2013 and it's under the chairman of David Gill, and it has 10 members nominated from various practice groups within the Society or co-opted onto it. And it deals right across the Society, property, construction, the whole lot. The purpose is to address dispute resolution, including to maintain practice and competence of practicing members, to keep people updated, particularly practicing members who are involved in dispute resolution. Publish practice statements, guidance notes and papers on dispute resolution, and promote CPD training and other developments as they arise. So the purpose is also to seek to foster pupillage and mentoring. Now pupillage isn't that easy because pupillage requires the agreement of the parties in dispute, and I think many of the professional bodies have tried it, but not with a lot of success, it has to be said. Provide dispute service, including managing panels and providing information for the President when making nominations, and that's not just for the President's own nomination of people, but for the industry generally too, if they want to select a mediator, conciliator or arbitrator. There are panels there of people who have experience and have been trained in the respective procedures. The committee is also responsible for the dispute resolution function within the Society, and it promotes the society in all aspects of dispute resolution. So on the web, there are panels in relation to both construction and property. The construction panels are conciliators, mediators. There's been an increase in appointments for conciliators, mediators. There's been 7 so far this year. There's also a panel of arbitrators, which would not be as extensive, it has to be said, as the conciliators or mediators panel, and then independent expert determination, which isn't used, I have to say, very much in the construction industry. Of over 100 disputes that I would have dealt with, I think I've acted twice as an expert determinator. And one of those was where a party took RII contracts, simply struck out the word arbitrator and put in expert determinator. And the other one, I wasn't actually appointed as an expert determinator, I was appointed originally as an adjudicator. And before I started, the parties changed me into a conciliator. And out of the conciliation meeting, it was agreed to do an expert determination. So I've very rarely come across expert determination in construction disputes. Under the property side, there's a panel of arbitrators for commercial rent reviews, independent experts for commercial rent reviews. Now, there would be a lot more activity from the perspective of independent experts in the property side. Current market, a few appointments compared to a number of years ago where there would have been in excess of 400 appointments a year made by the Society President on the property side, that is. So membership of the arbitrators, independent experts, panels, a member of 10 years or cognitive professional qualification, so that would be chartered for 10 years, plus training, and expertise in arbitration or expert determination. As regards conciliation mediators panel, a member of the society and 10 years postgraduate experience as against chartership, and again completed a recognised training course in mediation and conciliation. Last year the society ran its first conciliation course over a 5-day period. Future developments then for the panels would include mediation and expert determination on boundary disputes. That would really be directed towards the geomatics and the building surveying groupings within the society as against QSs or general practitioners. And then mediation in relation to commercial rent disputes. Hasn't happened a whole lot as I understand it. I set up a mediation company back in the early 90s to deal with construction, engineering and property disputes, including rent disputes. And the one area that just didn't get off the ground was in relation to rent disputes. Parties seemed happy with the arbitration process for rent disputes, and I think that's probably the way it is still at the moment. Now, adjudication training. Adjudication is coming, and we'll look at that shortly, but just to give you the heads up on what we're looking at doing in relation to adjudication training. We set up a party chaired by John Curtin, a former president, with myself and Andrew Nugent, who's chair of the QS groupings and the Society's education people. And the first task there is to actually get ourselves correct trainers to train us. Again, the training is going to have to be correct, and the standard of training in the UK is relatively high. So we are looking to get trainers in the first instance to develop and deliver appropriate adjudication training. And we want to get a course that is going to be recognised within HTAC system, and that may involve bringing in a third level institution to assist in the lectures. We also would like the course to be recognised by the RICS, because the RICS course is itself recognised outside of the UK, and it is recognised within the UK as probably the best course there at the present. The RICS got involved in this very, very early on in adjudication in the UK. So the first task that the Society is going to do is to convert the arbitrators into adjudicators. And after that then to provide a 2-stage course. The first stage, the primary stage, will be for anybody who will be involved in adjudication. And that may be representing or working with one of the parties in an adjudication as against actually acting as adjudicator. And stage 2 of the course then will be for those people who want to actually act as adjudicators. And it's hoped to have all of that running fairly shortly, well, certainly by the autumn of 2013. So in relation to expert determination, there's a concerted effort to promote the service, and that is going on this year. Appropriate expert determination, where would it be appropriate for use? Well, it would be appropriate for use to assist an arbitrator or a court as an assessor or a joint expert with the agreement of the parties on issues of quantum, costs, defects and the like. The other one will be direct appointment by the parties to resolve mainly factual disputes. It's not arbitration, it's not adjudication, and it's not mediation or conciliation. However, common to all dispute resolutions, an expert determination, the expert must be neutral, must adopt procedures appropriate to a particular case. There aren't really procedures on expert determination. So you don't have the protection of the statutes, you don't have protection of the procedures set up by various institutions for arbitration, conciliation or mediation. They're not bound by the rules of evidence, but must disclose all documents, information received to each party. So in relation to bound by rules of evidence, you are bound by rules of evidence obviously in an arbitration, not in the mediation or conciliation, and not in expert determination. Must disclose all documents and information received to each party. That won't really happen in an arbitration, since all communications with the arbitrator are copied to the other party. But in a conciliation or mediation, you can receive documentation from one side and not disclose it to the other side. In fact, you cannot disclose it to the other side if you're asked not to. Unless otherwise agreed, the expert shall not consult parties alone. That again does not arise in an arbitration. If it did, you'd be guilty of misconduct and you'd have to withdraw from the arbitration. And in mediation conciliation, you can consult the parties on their own. Unless otherwise agreed, determination is final and binding. And the one I did last year, the parties agreed that it would be final and binding, no appeal to any courts or anywhere else. But it is normally final and binding in any event. Conciliation need not be, mediation need not be. Now, the other issue that's raising its head a lot is conflict of interest in relation to practicing mediators, conciliators, arbitrators. So there's a guidance note on that as part of a suite of appropriate best practice guides based on the RICS UK publications in relation to members' involvement in dispute resolution. Again, there's no point in reinventing the wheel. The RICS has done a good job on it, so we're taking that and adapting it as necessary. So compliance with practice recommendations should at least be partial defence to professional negligence claims. It's not an absolute defence, obviously, or full defence, but if you're following best practice, well, you're well on the way to a proper defence to any allegations of misconduct or negligence. Conflict of interest guide is an advice for is advice for members being considered for appointment as a dispute resolver, either by an appointing body or a disputing party. It doesn't matter how you get into it. Once you're appointed or accept an appointment, well, then you have to deal with conflicts, or potential conflicts of interest. So the purpose is to assist understanding of the main principles and consideration of identification of potential conflicts of interest and appropriate actions, redisclosures, and ensuring independence of an appointed dispute resolver. Independence is absolute. You either are independent or you're not. And the simple rule is if you have a doubt about anything, you have to disclose it. It doesn't matter when it arises, you must disclose it. The 2010 Arbitration Act of Article 12 states that when a person is approached in connection with his possible appointment as an arbitrator, he shall disclose any circumstances likely to give rise to justifiable doubts as to his impartiality or independence. An arbitrator, from the time of his appointment and throughout the arbitrary proceedings, shall, without delay, disclose any such circumstances to the parties unless they have already been informed of them by him. Now, once you inform them of a potential conflict or a possible conflict, and the parties are happy with it, that's it, you carry on. But if something comes to your attention, you have to disclose it to the other parties. I had to withdraw from an arbitration last year, quite a substantial arbitration, because it came to my attention, I didn't know this, but one of the parties realised that one of the witnesses would have been known to me, reasonably well known to me. And they raised it, and I considered it, and if the first decision is the arbitrator's, whether the arbitrator thinks it will not be a conflict or an issue for them in remaining impartial. So that's the first decision, but then the parties can query that, and if necessary, query the arbitrator's view of non-conflict to the High Court. But in that instance, I decided, and it would be the best advice to anybody acting as arbitrator, if the issue is raised, simply stand back. It was made known to me that there would be a witness. That was known to me, and the only solution is simply stand back. Your absolute obligation is to the arbitration process and not to bring it into disrepute. So there's ongoing CPD training in relation to disputes. There's mediation, both for information purposes, again, for those who attend mediation, and further training for people who wish to act as mediators. The adjudication training, as I said, is being set up at the moment. And conciliation training for the current panel, which was based on the training course we did 12 months ago or 18 months ago, and that will have to be updated, and the training of the panel, people on the panel will have to be updated and maintained. And then there will be other courses, again, for interested parties, people who will be involved in conciliation. In relation to arbitration, we don't do arbitration courses. They're left really to third-level institutions generally. There's an arbitration course in UCD, certainly a lot of people do that. But one that we will be doing is making reasoned awards, because since the 2010 Act came in, it is really compulsory for the arbitrator to issue reasoned awards, unless the parties agree otherwise, but generally the parties will want a reasoned award. And they are entitled to it, in fairness. If you're going to decide an issue between two parties which is binding on them, they are entitled to know how you came up with the decision you came up with. So other planned publications, we have the Guidelines for Surveyors Acting as Arbitrators in Property Disputes, Guidelines for Surveyors Acting as Arbitrators, Independent Experts in Construction Disputes, Practice Statement for Surveyors Acting as Expert Witnesses. Then we have guidance notes for those practicing as conciliators, mediators, those acting as independent experts, and guidance notes for surveyors acting as statutory adjudicators. So that's when the construction bill is passed. So that will be prioritised, and I suspect it is being given priority at the moment. Now, adjudication. What is it and where is it coming from? It's been in the UK for the best part of 15 years. It's in Australia, it's in New Zealand, I believe, and many other Commonwealth countries. Current draft, now it is only a draft because it's gone back again in for reconsideration or more consideration by the Cabinet. My latest understanding is that it's going to Cabinet tomorrow, but whether it is or not, I don't know, but that's what I'm led to believe. So the current draft, adjudicator's determination is not enforceable if a matter is referred to conciliation or arbitration. That's what's becoming known as the no-teeth adjudication. The purpose of the adjudication bill, as envisaged and when introduced to the House by Senator Quinn, was really to facilitate the movement of cash flow through the industry. If there's a dispute over money, get a quick decision on it and get the cash flow moving. But as you can see, under its present drafting, if the matter is referred on to conciliation or arbitration, it's not enforceable. In fact, it's less effective than either accepted conciliator's recommendation, or a conciliator's recommendation, in fact, that's not rejected, as against, because you don't accept a conciliator's recommendation, you simply don't reject it. That becomes binding. Or a rejected conciliator's recommendation under the public works contracts, because again, in that instance, under the public works contracts, the money can still be paid over provided a bond is given by the person receiving the money. But in the adjudication, as you can see under its present draft, the money stays where it is. The consequences of the adjudicator's determination is up for review at the committee stage, which is happening at present. And this will have little effect on how adjudication is conducted, the panels and the training. So we can still go on with the panels and we can still go on with the training, irrespective of, we suspect, the reviews that are ongoing at the moment. So some of the key issues on the adjudication bill: the disputes that can be referred to adjudication and the timing of referral to adjudication. So can you deal with all disputes and any dispute under adjudication? No, I think will be the answer. The right to refer to adjudication any dispute relating to payment under the construction contract paying disputes, section 6.1. It must be a payment dispute or a dispute related to payment. And there must be an actual dispute. Under section 4, this means that a claim for payment must be submitted, and either the paying party has delivered a response to a claim, and the claiming party disputes that response, or there is a failure on the part of the paying party to either pay what is claimed or pay what they assert is due on the due date. So there must be an actual dispute, recorded dispute, in relation to payment. It is not clear whether a dispute on the action by the claimant to suspend works under section 5 comes within this definition. But it is arguable that any action arising from a dispute in regard to payment comes within the definition of payment dispute, provided the claimant has asserted and notified a right to be paid, and either party has failed to do something required as a consequence of making that application for payment. So there must be an application for payment. There must be a dispute in relation to that application. There must be a response, a difference of opinion. It would be suggested that a dispute with respect to defective work could only become a payment dispute when the claimant seeks payment for the defective work and the other party has either disputed the claim or failed to pay it. So linking the defect to a lack of payment or a payment dispute. The right to refer to statutory adjudication will override the written terms of a contract. So you can't contract out of it. It's a statutory adjudication and it will apply to all contracts. Parties will have a right at any time to issue notice of intention to refer the payment dispute. They can refer it at any time once there is a dispute. Now, the appointment of the adjudicator is within 5 days of notice. It's actually 4 days after the notice is served. And the parties can agree to appoint from their own choice. It does not have to be from the minister's appointed panel, and we'll come to that shortly. This will allow for each institution to continue to have their own panels for the purposes of allowing parties to select. So the parties can select from various institutions' panels. The wording does not appear to preclude parties agreeing that the appointment can be by the president of a named institution. There's nothing in the bill appears to prohibit how parties can agree their own choice. Or the parties can agree to refer to the minister's panel. Or failing agreement, appointment can be referred by either to the minister's panel, that's section 6, and the chairman of the minister's panel shall appoint the adjudicator where referred. And there's no time limit set on appointing an adjudicator from the panel. Remember, adjudication is supposed to be a rapid process. So when does the adjudication commence? When the adjudicator appointed to the adjudication commences. So the timing of the appointment. So when you're appointed, that's when the adjudication starts. In the case of appointment by the parties, agreement presumably is when the adjudicator has accepted the appointments and the conditions of that appointment are accepted by the parties. B, in the case of the Ministers' Panel, appointment is when the parties are notified who the appointee is. I presume what will happen is that whoever is working on the chairman of the panel will approach the intended appointee and see is there any conflict or anything with the two parties, and then will be appointed and the parties will be informed. As in the UK, this can leave the parties at the mercy of the appointed adjudicator in respect of rates of fees, etc. Now, rules of conduct and practice. Well, as in all dispute resolution methods, the adjudicator must act impartially in the conduct of the adjudication, comply with the Minister's published code of practice, which hasn't come out yet, may take the initiative in asserting the facts and the law, unlike an arbitrator, may deal with several payment disputes arising from the same contract or related contracts at the same time, so you can deal with a number of disputes, and may correct a decision to remove clerical or typographical errors, but may not reconsider or reopen a decision. As is in the case of an arbitration, you can correct clerical or typographical errors, but you cannot go back into the decision. The adjudicator must act in good faith, as is the case with all of these dispute resolution methods. The adjudicator determines the amount of his fees, costs and expenses and who will pay. Again, similar to arbitration, but not conciliation or mediation, where the parties usually split the fees. The adjudicator may resign on giving written notice to the parties, and the parties are liable jointly and severally for the fees, etc., up to the date of resignation. Again, you can resign from conciliation and mediation, but you cannot resign from an arbitration. Adjudicator's appointment may be revoked by agreement of the parties at any time. The party is liable again jointly and severally for the fees up to the date of the revocation. Now, the adjudicator's decision is binding until the dispute is finally settled by the parties. The Ministers' Adjudication Panel, Section 8, just a note there, the SCSI and Engineers Ireland have offered to administer the panel, but there is no cross-industry agreement yet as to the making of a joint approach to the Minister to set up the Ministers' Panel. So from time to time, the Minister shall select persons to be members of the Adjudication Panel. The Minister shall select one of those members to chair the panel, and membership of the panel is subject to renewal and reselection every 5 years. So who can be on it? The Minister may remove a member for good and sufficient reason. The member may resign from the panel by notice in writing to the Minister. And selection shall have regard to the experience, this is the selection of the adjudicator, experience in dispute resolution procedures under construction contracts, and expertise in dispute resolution procedures under construction contracts, and must meet the description of the persons outlined in Section 8. And that is, the National Panel should be open or will be open to registered professionals as defined in Section 2 of the Building Control Act 2007, that is, registered architects, registered quantity surveyors and building surveyors. The registration is run by the RIAI and the SCSI for their respective members. A chartered member of the Institute of Engineers of Ireland, barrister, solicitor, a fellow of the Chartered Institute of Arbitrators, or an equivalent qualification obtained in other EU member states. So, a registered architect, QS building surveyor, chartered engineer, barrister, solicitor, or a fellow of the Chartered Institute of Arbitrators. Now, code of practice for conduct of the adjudication. Now, the Minister may prepare and publish a code of practice governing the conduct of adjudications. He may not. The option is there. Note, as currently drafted, neither the Minister's panel nor the Code of Practice are essential for the Act to operate, as the parties retain the freedom of choice on how and whom they appear as arbitrator or appoint as arbitrator. Statutory adjudication has operated in the UK for 14 years with no national panel and no statutory code of practice. But however, the lack of a code of practice has resulted in an awful lot of case law on adjudication in the UK. There have been a lot of these adjudications gone into the courts and back out again. So what's the current position? Minister Hayes has postponed for a further 2 months or so introduction of the government's amendments for the second stage reading in the Dáil, but it's getting there. The current expectations are that if there is the political will, could be dealt with by the summer recess. Unlikely to be enacted before the autumn, and there will be a transition period will be required. May even push it out until 2013, the transition period. Just some adjudication case law in the UK, just to see what's going on over there. The Harrington case, there was a breach of the rules of natural justice, which will apply to adjudication. Because the adjudicator's determination exceeded the jurisdiction, there has been an inordinate amount of case law in the UK in relation to the jurisdiction of the adjudicator. What precisely has the adjudicator been asked to decide, and has the determination stayed within the boundaries of that appointment, or have they strayed outside of it? Adjudication was to be in compliance with the scheme and found not to have complied. The scheme is an amendment to the original adjudication. Adjudicator lost the right to fees because the adjudicator did not do what the adjudicator was employed to do or appointed to do, and lost their right to any fees. And the Bottomwood decision in 2007, the scheme restricts adjudicators to deciding a dispute as a singular unless otherwise consented to by the parties. So if parties have not consented to more than one dispute, you are stuck with one dispute, and that's what you decide on. Continuing with the rules of natural justice, failure to act fairly and impartially as between the parties, giving each a reasonable opportunity to put their case and deal with that of the opponent. Remember, this has all been done in a very, very, very short time frame. It's 30-odd days, I think, in the UK, from appointment to determination. It's not like an arbitration which can go on for months or years. This is very quick and rapid. So you have to give both parties the opportunity to present their case in that short time frame. Failure to adopt procedures suitable to the circumstances of the particular case, if there are no procedures. Exceeding its powers, O'Donnell developments versus buildability, so you cannot exceed whatever powers you are given. Failure to conduct proceedings in accordance with procedures agreed by the parties. Again, procedures. If there are a set of procedures, you must operate within them. Failure to deal with the issues put to the tribunal, the same as in arbitration. You have to make a determination or a decision on all of the issues before you. No more and no less. Adjudicator, arbitrator exceeding its powers. Again, you have to stick within your powers. Uncertainty or ambiguity in the award. An award which is uncertain on its face is unenforceable at common law. If there is ambiguity in your determination, it cannot be enforced. It has to be absolutely clear, or else what's the judge to do? The judge will not correct it for you or make sense of it. Your own determination or arbitration award must make its own sense. Award obtained by fraud or procured contrary to public policy, well, that's fairly obvious. Failure to comply as to the form of the award, e.g. if reasons required are not given, it's not in compliance with what you were asked to do, and it's not enforceable. Irregularities in the conduct of the proceedings or in the award, the courts must be satisfied that it has caused or will cause substantial injustice to the applicant, So the person who complains about whatever it was the arbitrator or the conciliator did, it must cause a substantial injustice, not a petty thing. It must be of a meaningful effect. That which applies to arbitration is basically applicable to adjudication. That's what the courts are saying. An adjudicator is acting as if he were an arbitrator, except it is very, very fast track. The point or issue in relation to if there is a question raised about the conduct of the adjudication, the point or issue must be one which is either decisive or of considerable potential importance to the outcome and not peripheral or irrelevant. The provisional nature of the decision also justifies ignoring non-material breaches. So the breach that you're accused of must be a material breach. Now, the other question that arises is, well, is there actually a dispute? Is there a dispute that you're being asked to determine? The dispute can differ. The extent to which the claim may change, quantum changed. It's a matter of factual degree. The dispute originally might have been about €120,000. Then you get the presentations, and it's 150,000. Which dispute are you dealing with? The 120 that was referred to, or the 150? Beck v UK Flooring in last year, 2012, claim did not crystallise into a dispute. There must be an actual dispute. In that instance, it was a 5-day period. But there was a close of business for the Holy Thursday to the Tuesday after the Easter bank holiday. So the 5-day period hadn't run its course. There was no dispute. Cantillon versus Uvasco in 2008, Aikenhead went through it and said how and when a dispute can arise. A, should not adopt an over-legalistic analysis of what the dispute between the parties is. We'll go over the top of an analysis of it. B, one does need to determine in broad terms what the referred disputed claim or assertion is. You must know what is the dispute. You can't move on without it. One does need to determine in broad terms. C, one cannot say the disputed claim or assertion is necessarily defined or limited by evidence or arguments submitted by either party to each other before the referral to adjudication or arbitration. In other words, there's a dispute. Both parties have submitted documentation to each other to sort out the dispute. It hasn't been sorted, so now they have decided, right, we're in dispute, and give notice. The adjudication is not confined to the documentation that was exchanged prior to the formal notification of the dispute. I had that myself only last Friday in relation to conciliation. Party questioned, am I limited in my decision to consider documentation that was considered by the employer's representative in relation to the dispute that's gone to conciliation? Or can I hear other evidence? So it's obviously raised its head in adjudication as well. The ambit of an adjudication or arbitration may be unavoidably widened by the nature of the defence or defences put forward. Somebody putting forward the defence may widen the dispute. They'll introduce other issues as the defence. My defence to not paying you money is that there's a big ugly defect in the building. So now, what was the money dispute encompasses the defect. Now, the Arbitration Act 2010, some issues that have arisen. I suppose the biggest one, and of concern for contractors, is what Jerry calls an abuse of a dominant position by the public employer under the public works contracts. It is, I suppose, to be fair, an abuse of a dominant position, and it is to be found in the form of tender. They didn't change the arbitration clause, and they didn't change the arbitration procedures. They introduced it in the form of tender, where it states we, that's the contractor signing the form of tender. We also agree that should a dispute arise under the contract formed by acceptance of this tender, and that it is referred to arbitration to the extent permitted by law under the Arbitration Act 210. Now, where they're coming from here is if there is an arbitration, similar as a High Court case, the employer, to protect themselves against the costs, because believe it or not, the costs may actually exceed the award in an arbitration, would not be unusual. To protect yourself against the costs should you lose, you will make a sealed offer to the claimant. Claimant must beat that sealed offer, or else the claimant will be responsible for your costs from the day you gave the sealed offer. Even if they are awarded money, but they're not awarded the amount of money that you offer them. So this is, and the sealed offer has not been made. So even if I have not made the sealed offer, which is what I should do in the normal course of events to protect myself against costs, or where a sealed offer has been made and the contractor's award is greater than the sealed offer, then each party will bear their own costs in relation to the arbitration proceedings. So in a nutshell, what they're saying is, Mr. Contractor, you will pay your own costs, even if you win. Mind you, if you lose, you'll pay our costs as well. But if you win, you will pay your own costs. And that can make the whole arbitration just not worth running. The risk is too high. Because the costs of an arbitration are at least equal to the costs of a High Court action. Section 21 of the 210 Arbitration Act, the parties to an arbitration agreement may make such provision as to the cost of the arbitration as they see fit. However, an arbitration agreement, A, to which one of the parties to the agreement is a consumer, that's a simple individual, and B, a term of which provides that each party shall bear his or her own costs, shall be deemed to be unfair term for the purpose of these regulations. That's the European Consumer Regulations. Notice what they're saying. If there's an arbitration on a holiday dispute, for the sake of argument, or some purchase of a car or something like that, and there's already in the purchase agreement that if there is an arbitration, each party will pay their own costs. That's not allowed. Because you've got a big multi-glomerate who's enforcing on the other party that you will pay your own costs. It's really putting it up to you or telling you to stay away really from an arbitration. That has been referred, as we understand it, by the CIF to the European courts. Now, grossly unfair terms in respect to payment periods, interest as defined under regulations may be referred to the Circuit Court or arbitration. This is the Late Payment Transactions Regulations 2013. If the parties fail to agree an arbitrator, they may refer the matter to the Law Society to appoint an arbitrator. So the parties in the first instance can go to the Circuit Court or go to arbitration. The arbitrator's decision is specifically stated as not final and binding on a point of law, which is appealable to the High Court. That is not the case generally in arbitration. Arbitration subject to the 2000 Act, but reference on point of law appears to conflict with Article 34.2 of the Arbitration Act 2000, well, the UNCITRAL regulations which we brought in through the Arbitration Act 2010. Just to move it on the Liaison Committee current issues, dispute resolution clause is under review. That's clause 38 in the RAI contract. There's a proposed changes yet to be approved, which we're looking at, would include dispute to be first referred to arbitration. You refer dispute to arbitration to get within the statute of limitations, stop the clock from ticking. But you do no further action required until the conclusion of a conciliation. Basically what we're saying there is conciliation, prefer you to go to conciliation, but obviously you can't let the clock run by, so you put in the notice of arbitration, stop the statute of limitations, and then continue with a conciliation. Procedures to follow: the Engineers Ireland published procedures on conciliation. They're recognised and accepted by many in the industry. And the recommendation process will only proceed if the parties agree to it after failing to mediate a settlement. Again, this is the mix between mediation and conciliation. Normally the conciliation, you will act as the mediator and try and get a mutual agreement between the parties. And failing that, you would issue a recommendation. So what's looked at now in the RA contract is the possibility that before you go into the recommendation process, you only do that if the parties agree to it. There is the new RIA form of contract. It's going through consultation with the other institutions at the moment. A working group from the RII have tabled draft for the consideration. And the aim of this is to match the form and functionality of the public works contracts. Clauses will be grouped to each function, contract to address wish lists of the constituent bodies, and the draft is being reviewed by all constituent bodies, and the intention is to have the final draft ready for review in the summer of 2013, with a view to publishing it early in 2014. So it's being reviewed at the moment by the Society of Chartered Surveyors, Construction Industry Federation, Engineers Ireland, Association of Consultant Engineers. Issues delaying this at the moment are the new building regulations and the building contract bill. They're both due out reasonably shortly, so they're postponing the finalisation of the new contract, new RAI contract. Just very briefly, we'll finish up on this. Conciliation, they have eventually found their way to the High Court. Wise Construction Limerick Limited versus Donal Ryan Motor Group, Roscrea, 2012, unreported. The conditions of contract in this instance were the RII 2002 with the conciliation clause. The employer refused to pay on foot of payment certificates issued at practical completion. The matter was referred to court, where the employer successfully had the matter referred to conciliation. Notably, public works contracts outcome could be different because conciliation is optional, but under the RII, conciliation is compulsory. So the RII, so off the court and back to conciliation, the RII appointed a conciliator on request of the parties, but the employer refused to engage. He failed to sign the appointment that was issued by the RII, failed to pay the conciliator's fees, and failed to make a submission to the conciliator. Just didn't want to know. Contractor discharged the fee and requested the recommendation. So the conciliator went through the process. The employer refused to engage in the process. Recommendation was ready. Contractor discharged the conciliator's fees, and out came the recommendation. The recommendation said payment of the certificate pursuant to the architect's certificate, please. Neither side rejected the recommendation in the time required. 20 days, I think it is, top of my head, to reject a conciliator's recommendation. If you fail to reject it, if both parties fail to reject it, it becomes binding. So neither party rejected it. The contract provides it shall be final and binding on the parties. Needless to say, the employer failed to pay the recommendation, and the contractor went off to the court to get a summary judgment. Now, the employer claimed a lack of jurisdiction by the conciliator, issued a recommendation without submissions from the employer, and took no account of defects, alleged defects in the building. McMenamin J. held that the contractor was entitled to judgment in the sum claimed, but placed a stay in execution in light of alleged defective works, and the matter was ultimately settled out of court. In fact, what happened was the judge said, right, I accept the recommendation, however, there are defects, so sort out the defects. I think the money was actually had to be paid into court in the meantime, and the judge actually sent them back to another conciliation to sort out the defects, and what they did was to sort out the whole thing in the second conciliation. There was another case like that involving a liquidation, and again the court upheld the recommendation, however, withheld enforcement of it pending the outcome of the appointment of the new contractor and doing a settlement between how much extra did the employer have to pay because of the liquidation of the first contractor. But again, they enforced the recommendation. Public Works contracts, the 2011 version, 1054, the termination of the employer's representative notified to the contractor and the employer under subclause 10.5, ER's extension of time under the ownership, shall be final and binding on the parties unless. So this is the termination of the employer's representative. There's a dispute going on, goes to the employer's representative, the architect, the engineer, whoever it is, and they make a determination. And that is final and binding now. That determination is final and binding unless after 28 days after receiving notice of the determination, or subclause 10.53, applies within 28 days after the determination is taken to have been made, the contractor or the employer gives notice to the other under subclause 13.1, disputing the determination and referring the dispute to conciliation. What this means is every time there's a determination, If the contractor is unhappy with it, or indeed if the employer is unhappy with it, they have to call for a conciliation within 28 days. So you can have a whole plethora of conciliations going on the same contract. I did the civil engineering one down the country just before Christmas. I think I was the third conciliator on the project. I'm doing another one down the country at the moment. And my first conciliation is 20 determinations in dispute. The next one is, I think, 60 determinations in dispute. And on the project, which was a relatively simple project, there are over 400 determinations in dispute. So this is what's happening now. The contractor was forced to make a formal issue of it and go off to conciliation. They've also introduced in the 2011 edition, if the employer's representative does not make a determination, it's deemed to be a negative determination after 28 days, I think it is. Also on determination, the contractor or the employer must, so either the contractor or the employer must notify the employer's representative and the other side that they disagree with the determination notified by the employer's representative. So notify the employer's representative and the other party, and secondly, give notice to the other side under subclause 13.1, referring the dispute to conciliation. So you automatically have to refer to conciliation. That seems to be creating disputes rather than trying to stop them. Just briefly, the SCS is delivering an experienced and proactive dispute resolution service to the industry. Adjudication training will be delivered as soon as the Act is ready, and that will come into place fairly shortly. SCS will promote use of expert determination. I think that's quite frankly going to be more on the property side than the construction side. Statutory adjudication process, if the bill is enacted, will probably be as the current draft, but we don't know that, but that's speculation really. UK experience is that rules of natural justice and jurisdiction as applied to arbitration also apply to adjudication. The Arbitration Act, abuse of dominant position by the public bodies, contrary to the UNCITRAL rules. Liaison Committee, new conciliation clause, and there's a new contract coming through the Liaison Committee and through the RAI contract. Conciliation courts have finally recognised the binding nature of the recommendations, and conciliation of the public works contracts has no option but to refer to dispute resolution if parties are unwilling to accept the ER's determination, which is otherwise final and binding. So you have to go off to dispute straight away on the public works contracts. Thank you for listening.